Hello, I'm attorney Daniel Marr from the Nashua law firm of Hamlin Kerrigan here in Nashua, New Hampshire. I've been practicing law here in this state for approximately 36 years and in the Commonwealth of Massachusetts for approximately 28. In today's vlog, I'm going to be focusing in on getting a lien as part of your initiating of a lawsuit against somebody who owes you money. It's called the judicial lien, but also primarily called an attachment in New Hampshire. And there's a process upon which you can get what's called a pre-judgment attachment, which means before you get a final judgment in the case, you get a lien. Now, the benefit of that is getting a lien on somebody's real estate or bank account. We're going to talk about that process. That freezes up that real estate, bank account, other assets while you wait to get a judgment in the case. The case could go on for a year or more, and you want to make sure that the debtor, the person that owes you money, or the company that owes you money, doesn't dissipate those assets, doesn't transfer the asset to somebody else and take the money and put it somewhere else, or if it's a bank account, pay other bills, because you want to get paid first, obviously. So the process in New Hampshire for a prejudgment attachment is, first you have to show that there's a reasonable likelihood of success on the merits of you getting the amount that you're seeking plus interest and costs. So if maybe the contract that you have also have attorney's fee provisions, you can put that in as far as what you estimate the attorney's fees are, the amount of the principal amount, if it's a loan, the principal amount of the loan, and anything else there. If it's a breach of lease, you can address what your damages are and spell it out very clearly to the court so they understand why you're asking that amount of an attachment. The attachment can go against the person's real estate or the entity's real estate if they have it. You can also go what's called a trustee process attachment, which under the New Hampshire laws, you have the right to go to the bank and tell them, as what's called a trustee process defendant, you get a rule from the court saying, hold this money. If there is this money here, maybe it's $200,000, maybe it's $20,000, maybe it's $2 million. If you have this money in the account, hold it. And they have a certain obligation. There are certain rules that they have to follow, but they can hold that money, and that freezes up that money for ultimately a decision. If they freeze up that money, there's also a possibility of doing something called a bond, where they remove the attachment by getting a bond, or they can show, look, I got plenty of money. So if you're suing, I'm making this up, Microsoft or IBM or some very financially sound company, and you're looking for $20,000 or $200,000 or even frankly $2 million, more than likely, even if you show that you have a likelihood of success on the merits, they can come back and say, I got plenty of assets, I got deep pockets, here's some proof of this. Or maybe the court might just take it at face value if you're talking about a publicly traded company that's doing well. But you can't go and just lien something to harass people. You got to do it for security purposes. So you're able to get a lien on somebody's real estate or their entity real estate or the bank accounts, and there's other assets you can get too. I've also done something called a bulky article attachment. It's a little more cumbersome, but you can get an attachment on a whole bunch of equipment too. If there's a lien on the property, a voluntary lien, that takes precedent. So if there's a mortgage on the property, obviously that takes precedent. Property taxes on real estate take precedence over your attachment. If it's an individual's home, their homestead exemption being $120,000 in New Hampshire, it's different in Massachusetts, but for New Hampshire it's $120,000. That takes precedent for that person, with some exceptions to the rules if they've done some particular bad acts. But generally they have that. So you still might find out if you have a $200,000 mortgage and the property is worth $600,000, that's $200,000 plus the $120,000 homestead, that's $320,000. There's still plenty of equity there, and it's worthwhile getting a lien against that property if you can, to make sure that they don't take out a HELOC, which is a home equity line of credit, or some other, or transfer the property and dissipate this ability for you to get paid. So it's all worthwhile. I've dealt with these things quite a bit. There's also a possibility of getting what's called an ex parte attachment. Under limited circumstances, you can show that if you don't get this attachment without notice to the other side, they might dissipate the assets. It happens a lot with bank accounts. So if you're able to show that this person or entity is not paying their bills, and you know of this bank, and if they get notice of it, they're going to withdraw from that bank account or pay some other bills from that account, you can convince the court to get an ex parte attachment. If you also are a buyer of some real estate and you're trying to force the sale of the real estate because you're ready, willing, and able to buy it, it's called a specific performance action. I've dealt with this in other vlogs. You may be able to get an ex parte lien on that property too, just that property, so they can't sell to a third party that doesn't know about the case. So because that third party, when they look in the registry of deeds, they say, well, wait a minute, here's this lien on this property. I'm not going to buy this property with this lien on it. So you can do it for those purposes. All of that I've dealt with quite a bit. Happy to help if the circumstances arise. You can give me a call at 603-883-5501. It's Dan Marr, 603-883-5501. There'll be an intake process and conflict checks, but if it all works out, I'm happy to discuss the matter with you. You can also check out my various vlogs on a variety of topics at our firm website at nashvilllaw.com. Check out my bio and then click onto the YouTube channel and you'll be able to see my weekly vlogs. Look forward to working with you if the opportunity arises. Again, my telephone number is 603-883-5501. Thank you.